Evening, everyone. I hope you are healthy and taking care during these difficult days. I'm Patrick Mclaughlin, President of CCE, the Council for Court Excellence. Our mission is to enhance the justice system in the district to serve the public equitably, and as just one part of our mission, CCE works to educate the public about that system. A distinguishing feature of our courts and government institutions is openness to public scrutiny. Citizens and the media are generally accorded some right to examine the grounds for official decision-making. In times of crisis, transparency and access to information are particularly crucial. In furtherance of CCE's educational purpose, we are proud to host tonight's panel on the challenges that COVID-19 has posed to ensuring public access to the courts and government agencies, to official information, and more. Thank you to tonight's generous sponsors: Aiken Gump, Arent Fox, Arnold and Porter, Baker Botts, Ballard Spar, Brian Cave Leighton Paisner, Bowie Schiller, Covington and Burling, Davis Wright Tremaine, Lockheed Martin, Williams and Connolly, and Zuckerman Spader. All of these firms and their leaders have been active substantive contributors at CCE and valuable financial supporters, which allows us to offer free public programming like this to our community. And of course, thank you to our esteemed panelists. We look forward to hearing from each of you. Now I will turn the program over to our moderator, James Mclaughlin. Jim is the Washington Post's Deputy General Counsel and Director of Governmental Affairs, where he is principally responsible for newsroom-related legal issues and litigation, and oversees the Post's involvement in legislative and lobbying affairs. Before joining the Post in 2006, he worked at Covington and Burling and Zuckerman Spader, where he gained experience in a wide range of civil and criminal litigation matters. Jim also completed a one-year fellowship in First Amendment practice, focusing on access and prior restraint cases as the McCormick Tribune Legal Fellow at the Reports Committee for the Freedom of the Press. He is a graduate of Yale Law School, an adjunct professor at Georgetown University Law Center, and serves on a number of boards, including CCE's. Please welcome Jim Mclaughlin. Jim?
Thank you, Pat. I'm delighted to be here, and I thank all of you for joining us tonight. I regret that it's not in person, and I hope when we get to the other side of this pandemic, whenever that may be, we can all meet up in person and have a beer in happier times. But for now, we've assembled a terrific panel. We're going to be talking tonight about the challenges of ensuring public access to court records and government proceedings, court proceedings and government proceedings in the executive branch during a pandemic, which is uncharted territory for all of us. And we've got a distinguished panel who I'll introduce one by one in a minute to help us walk through those issues. But first, I wanted to say, first of all, thank you to the CCE staff who have put this together. Especially Misty Thomas and Casey Anderson. They spent a lot of time making sure that the technical aspects and the substantive programming comes together in a way that I think you'll all really enjoy. I want to give a quick overview of how we're going to proceed tonight. We have four panelists. I'm going to give them each the floor essentially to speak for a few minutes about sort of share an overview about how the pandemic has affected public access to their institutions. And each one of them comes at this from a slightly different institution. We are going to reserve about 20 minutes for audience questions at the end. And as we're doing this, if you have a question, feel free to enter it whenever it comes up, whenever it comes into your mind, using the Q&A feature on Zoom. I think we've all spent a lot of time on Zoom lately. And I think many of us, most of us are familiar with how that works, but Misty and Casey will be moderating, sort of curating the Zoom, the Q&A questions, and we will reserve time at the end of the discussion to get into those. With that, it's my pleasure to introduce our four panelists for tonight. I'll go in alphabetical order. While we regret that DC Attorney General Karl Racine was unable to join us this evening, after all, we're very excited to welcome his colleague, Chief Deputy Attorney General Jason Downs, to the panel. Before joining the Office of the Attorney General, Jason was a partner at Downs Collins, where he handled matters that involved an overlap in both civil and criminal proceedings. Jason also serves as a faculty member for the Harvard Law School's Trial Advocacy Workshop and as an adjunct professor at the University of Maryland School of Law. Continuing alphabetically, Jason Leopold is an Emmy-nominated senior investigative reporter for BuzzFeed News. Jason is a member of the reporting team named a finalist in 2018 for the Pulitzer Prize in International Reporting. His work, especially his Freedom of Information Act work, which you'll hear more about tonight, has been profiled by dozens of radio, television, and print outlets, including a front page story in the New York Times. Our next panelist is the Honorable Trevor McFadden, U.S. District Court Judge in the District of Columbia. Judge McFadden was appointed to the federal bench in 2017. He had previously served in the U.S. Department of Justice in several positions, including as counsel to the Deputy Attorney General, as Deputy Assistant Attorney General, and as an Assistant United States Attorney for the District of Columbia. So we're very fortunate to have Judge McFadden with us tonight. And finally, Katie Townsend is the legal director for the Reporters Committee for Freedom of the Press, which, as Pat mentioned, is sort of an alma mater of mine, having been a legal fellow there a long time ago. Katie joined the Reporters Committee as its first litigation director in 2014. Before that, she was an associate in the Los Angeles office of Gibson Dunn, where her practice focused on media and entertainment litigation. And Katie is one of the most seasoned litigators in the country and one of the most experienced litigators in the country on press freedom issues, including public access to the courts and court records. So her expertise is also highly relevant tonight. Before we dive into the discussion, I would like to remind you that the CCE is a small nonprofit organization. It's proud to be able to offer this program as a free community service. But as Pat mentioned, events like this take time and effort to put together. If you enjoy what you see tonight in the program and you want to support CCE, please consider donating at www.courtexcellence.org. Again, www.courtexcellence.org. So with that in mind, let's get started. As I said, I'm going to give each of the panelists the floor to kind of give us their big picture view on how they think public access has been affected in their areas of practice during the pandemic. I want to start with Judge McFadden and the federal courts. And Judge, if you could just kind of give us an overview of what is going on right now in your court, the U.S. District Court for the District of Columbia. We're now in month 6 of the pandemic, and can you just kind of give us the lay of the land? Are there trials happening? Have there been jury trials? How are public proceedings being conducted when everyone has to be doing it virtually? So I'll turn the floor over to Judge McFadden to just tell us how his court is adjusting to the pandemic. Judge?
Thanks, Jim, and it's a pleasure to be with you all tonight. Back in mid-March, which seems quite a while ago now, our Chief Judge, Beryl Howell, first issued a standing order closing the court to all in-person hearings and trials. And the court remains closed as of today. We're currently hoping to resume jury trials on November 9th. And we hope to resume all other in-person hearings and bench trials as of September 14th. I should say, however, that has been a date that's slipped several times over the last few months as we continually reevaluate the situation on the ground here. So I'm not promising anybody anything, but we're hoping to be able to start non-jury trial hearings within a couple weeks and resume jury trials later in the fall. Wanted to talk a bit about what we're doing and why we've done what we've done. Obviously, the hardest part about in-person hearings would be jury trials, and especially criminal jury trials. On the one hand, they are in many ways the most dangerous for us as individuals in the terms of potential exposure to the pandemic of any types of hearings we could have. Just think for any criminal jury trial, we typically have at least 50 prospective jurors gathered together for a veneer. You would have at least the defendant, often deputy marshals and defense attorneys, often congregating in close spaces at a counsel table or in the back in a holding cell trying to talk to one another. You have 12 jurors, 14 jurors with alternates sitting in that small jury box, and then in the jury deliberation room in the back of the courtroom that I imagine many of you have been in at one time or another. And that's not even talking about the potential exposure for the defendant and others if the defendant is detained and coming back and forth from the DC jail. So there's a lot of especially difficult issues around trying to hold a jury trial, which is a main reason why we haven't done any since March and don't plan to until at least November. But on the other hand, it's in a criminal trial that you especially see the constitutional and legal imperative for moving it forward. You have the Sixth Amendment, which assures defendants the right to a speedy and public trial. You also have the Speedy Trial Act, an act of Congress that sets strict deadlines for timelines within which a criminal case should be brought to trial. The Sixth Amendment, of course, also assures defendants of their right to confront their accusers, which is another wrinkle here in an age of social distancing. We at the district court have been working hard to try to figure out how to accommodate these different concerns. We now have, and certainly when we reopen, would expect to have temperature checks for anybody entering the courthouse. We have mask requirements for people to wear masks in the public areas in the courthouse. We're planning to move voir dires from the normal courtrooms to the large ceremonial courtroom to hopefully allow for maximum social distancing. So that solves one problem, but of course it creates another, because then you can probably just start one trial at a time. We're going to have plexiglass going up in the courtrooms to provide additional protection. We're going to be moving the jury from the jury box to the audience section of the courtroom to allow people to be spaced out. We're going to be moving jury deliberations from the jury rooms to larger grand jury rooms, and we're going to have social distancing signs throughout the courthouse. So these are all of the various steps, or some of the steps that we are in the process of taking to try to ensure that we can do jury trials in a safe and effective manner that respects the constitutional rights, but also the safety concerns that everyone have. Everything other than trials, we can basically accommodate virtually, and we've been trying to do that over the last number of months. On the civil side, we regularly now have conference calls or video teleconferences instead of status conferences and motion hearings. We now have listen-only public call-in lines so that anybody can be listening in to any one of these public hearings that otherwise would have occurred in the open court. It actually catches me by surprise sometimes. I've seen some stories in Law 360 about conference calls that I've had. Of course, I had no idea there was somebody, let alone a reporter, listening in, but that's obviously perfectly acceptable. but just a different scenario than typically an open court where you can tell who might be listening. On the criminal side, the CARES Act that was passed back in the spring gives special dispensation for video teleconferences with the consent of the defendant in criminal cases for everything except for trials. Trials still would need to be held in person. But using the CARES Act authorization, we have been moving forward with status conferences, plea hearings, even sentencings in some cases. We found that a number of the defendants and defense counsel prefer to go ahead virtually. One of the issues that defendants could face, even if they were allowed to come into court, is they may well face quarantine going back to the DC jail or another detention facility. On the other hand, there are some defendants who are seeking to push off their sentencing so that they can have an in-person sentencing hearing, and we absolutely are accommodating that. So I guess the bottom line, Jim, is that we are doing our best to make it work virtually, but trials need to be done in person, and especially criminal trials or jury trials. And so while I think we are moving forward with justice, I'd say that the longer the delay lasts, the more of a backlog there will be when we do resume.
One quick follow-up, Judge. Has it been your impression that other federal courts around the country are basically taking things the same way the DC District Court is, or has there been any variance to your knowledge?
Yeah, I'm not aware of any virtual jury trials anywhere in the country. And frankly, I at the federal level, I'm quite certain that would be improper. We would not be allowed to under the federal rules of criminal procedure. I think different courts, some have opened earlier. Obviously, each district is evaluating the circumstances based on the social and health risks in their own district. I think you are seeing some of our neighboring courts that are starting to open up around this time, some trying one-off trials to see how it works. I think our other sister courts here in DC, I don't believe that the Superior Court has opened, and I know that the circuit is doing only virtual hearings at this time.
Thank you, Judge McFadden. One of the odd things about the pandemic from the perspective of a media lawyer is that in some ways we have greater practical access to federal court proceedings because cases that we previously would have had to go down to the courthouse to watch a hearing, and you can now watch from home. So it's I guess time will tell how many of those accommodations remain in effect. But it's been kind of a weird mixed bag. I'd like to turn to Jason Leopold from BuzzFeed now, because Jason comes at this from the perspective of a FOIA requester and FOIA litigant and a reporter. Jason, I think, has, this is a guess, but I would think that he has more federal FOIA lawsuits to his credit individually than any other reporter in the country, perhaps. There's a lot of case law out there in the federal FOIA area that has Leopold in the case caption. Jason, what has your impression been 6 months into the pandemic? Has it slowed down your FOIA cases? And has it slowed down your reporting in general?
It has. It certainly has slowed down the FOIA cases quite a bit, and as well as the requests. I mean, I think we all know that FOIA is a battle. It's a battle getting records from various government agencies. Why is that? Well, there's a backlog. There's not enough, there's not enough funding to hire more people to process the requests. When the pandemic hit, what happened was, for the most part, FOIA was not seen as a kind of mission critical component that the federal government needed to keep in place to function. And then slowly what we started to see is on the state and the local level, that was the exact same thing. So the FOIA operations, the public records, operations shut down. And, just like in any kind of emergency, reporters depend on government agencies to provide them with records so we can inform the public about what's going on. I don't want this to come across as political, but it's going to just happen by the way the sort of climate that we're in, is that there's a culture of secrecy. There's a culture of secrecy when it comes to any sort of, controversial issue. And right now, the coronavirus, pandemic is political. It's been politicized. And so that makes it very, very difficult to obtain information from the government and on the state level as well, to find out what is happening with PPE, what is happening with, with case numbers. How do we get that information and provide it to the public? Well, we file FOIA requests, right? But then what we're finding out, or what we were finding out from March going forward, is that these agencies were shutting down, their FOIA operations. And so we were more or less not able to obtain that. And so at the same time, we do, I want to be very clear here, is that we're empathetic, sympathetic. We wanted to work with the agencies. We did not want these, government workers going into the office and contracting anything. But there was, there was no communication. It was very interesting, because it was only after I filed a request with FBI that I discovered that the FBI completely shut down their electronic submission platform, their FOIA portal, and wanted requesters to put requests in an envelope and mail it to the FBI, which at that time, at least in March, was, nobody wanted to leave their house. It's obviously different now. So it's been a challenge. And so when you already have this massive backlog, and it's already difficult to get information, this has made it much more difficult. The intelligence agencies, the agencies that have to work on classified systems at secure facilities, that's still for the most part kind of shut down, and have not. I certainly, for many of the cases that have been in litigation, have not been able to to obtain any records. But I also want to point out is that as the months go by, the news continues, right? We're still dealing with other issues in addition to the pandemic. So it's critical to get it. It's still critical for us to get information, and it's still very difficult. And I think one of the problems here is that we were unable as journalists to deal with in a sort of conjunction, kind of having a working relationship with any of these government agencies. It was more like, we're gonna shut this down, and then we have to kind of raise our fists and picket and say that's a bad thing, and here's why.
Do you know if there's been any differentiation between within the government between requests that relate to the government's pandemic response versus routine? I'll just call them routine or non-pandemic related requests, because it seems like an argument could be made that the public has even greater urgency to understand how the government is responding to this ongoing public health crisis.
Absolutely. In fact, that was many of my requests early on, and certainly, since then we filed a number of lawsuits to try to pry loose that information, because it's important to provide the public with, as I noted, with details in a timely fashion. So what happened, however, is that early on, when we'd file requests with, say, this CDC, the FDA, HHS, all the science-based agencies, and providing them with a time frame on, say, COVID-19 or coronavirus, they were getting inundated with requests like that. What happened after a month or so is that they started to reject or deny requests as being too broad, when using those, coronavirus or COVID-19. So they started generating, obviously, voluminous records, but they started to reject requests like that, which made it much more difficult. And that is still the case. So still have to go through the appeals process and say, hey, this is still, I'm reasonably describing the records, but it's become more of a battle. And as you see, these agencies that are not used to processing requests at this volume, they have their FOIA logs online, say they receive, 20 to 30 a month, they're now being inundated with hundreds and hundreds of requests, and still only having, the same amount of perhaps it's contractors or staff to process it. So while they are providing and granting expedited processing, it doesn't really help move it out faster. And so it's a battle. And, right now we're playing catch up. Just yesterday, if I could just throw in one example, is, yesterday from the CDC, the FDA, and various agencies, they finally, in response to litigation, have produced some records. And those are records related to hydroxychloroquine, right? Which we all heard, the discussions revolving around that from March. But we're kind of long past that. So point being that, that's 6 months, and it's, while we're, again, appreciative that they're, doing the best that they can, it's still haven't figured out, how to resolve it.
Yeah, and not only is the volume of requests up, but at the exact time when they can't go into the office and meet with the people that they would normally talk to, presumably in the course of a custodian search and
exactly.
So forth. Let's turn to the DC government, if we can, for a minute. Chief Deputy Downs, I'm going to stay, we talked about this, and I'm going to stay away from any legislative decisions that the DC Council has made in suspending DC FOIA. That's obviously not your department and not Carl Racine's department, the legislation. But can you tell us a little bit about how the DC government executive branch is responding to the pandemic and trying to make sure that citizens of the district have enough information about the DC government's operations?
Sure. And thanks, Jim. And first, thanks to the Council for Court Excellence for having me today on behalf of AG Racine. I'm sure if AG Racine were here today, he'd start off by saying that one of our core beliefs at the Office of Attorney General is public accountability and transparency. So as a starting point, I certainly applaud CCE for even organizing this conversation and inviting us to be a part of it. And I'm happy to speak on what we're doing at the Office of Attorney General as an independent agency here in the District of Columbia. As everyone has already pointed out, COVID has changed the way that governments have operated, but it has not changed OAG's commitment to transparency. We firmly believe that district residents need a window into what we're doing in our work, especially in moments of crisis like we find ourselves in today. This is the time where people need reassurances that government is functioning properly. So this is the critical time where we need to keep that window open. And that's why, for our part, we've done everything that we possibly can to maintain public access to the government and to the courts. And let me give you a few examples to directly answer your question, Jim. First, you mentioned the legislature suspending FOIA requirements, and I certainly won't go into that decision-making process because that's the legislator's prerogative. But during a time where FOIA requirements are suspended in the district, we've continued to respond to FOIA requests to the best of our ability. Now, the lack of physical proximity to our colleagues and the lack of access to our office space has made it challenging, and our FOIA officer finds it to be challenging to respond, but she is staying on top of the pipeline to the best of her ability. And candidly, we've responded to approximately 1/3 of the FOIA requests that we received during the course of the pandemic, notwithstanding the fact that the requirement to respond is suspended. And we've done so because we believe that transparency is important. And I suspect that this group in particular would be happy to know that we are prioritizing responses to the media. And the rationale is the media has such a broad audience. In fact, it has the broadest audience. And so to the extent that we're going to prioritize FOIA requests, we are prioritizing requests that come from the media because of the size of the audience that will apparently receive the information that we release. So public accountability, transparency is important to us. So second, we also push the council to build public accountability into the emergency legislation that was passed. First, the first COVID relief bill, it allocated quite a bit of money to procure PPE for contractors. And initially, there was not a mechanism for public accounting around that large amount of money. And so we asked the council to add an amendment requiring public reporting on procurements, which would obligate the mayor to keep a thorough list of grants awarded and to publish that list by June the 1st. So now reporters, competitors, and the public at large can view that list, review the information, ask questions, and push back where it's appropriate. We've also worked with the courts to try to find ways to push cases forward through the pandemic as safely as possible and as transparently as possible. And as Judge McFadden explained a few minutes earlier, the courts closed back in March, which delayed hearings, delayed jury trials, but we knew that could not last indefinitely because, as Judge McFadden pointed out, there are meaningful constitutional issues at play, especially in criminal cases. But on a very practical level, people want their day in court. And so we've been communicating with the courts regarding responsible mechanisms for proceeding with civil trials, with juvenile cases, and virtual hearings. In fact, we had a virtual trial that concluded today. It was a bench trial. This is not the first bench trial we've had. We've had a few bench trials now that have proceeded in Superior Court. And so, and as Jim noted, I'll agree that some of the changes that the courts have made have actually increased accessibility to the court. Now, the Superior Court publishes links allowing anyone to tune in to any of the virtual courtrooms. And now the Court of Appeals streams arguments. So in many ways, courtroom is just a click away for anyone that's interested. And finally, we are sticking with our pre-existing commitments to proactively promote transparency. So even before the pandemic set in, we had plans to create an open data portal around our public safety work and to release more data around our Cure the Streets violence interruption pilot program. And we've continued to move both plans forward, notwithstanding the pandemic. So now district residents have access to expanded data regarding violence interruption here in the district. You can check our website, it's there now. Our public data portal will be launching in a few months, and we're very excited about that as well. Now, this is not to say that we're perfect. We know that OAG is not perfect, no government agency is. We're always looking for ways to improve. So that's one of the reasons I'm thrilled to represent AG Racine and OAG on this panel. So if my fellow panelists or if the audience or if anyone has identified blind spots that we should be addressing, please let me hear them. By all means, we want to know about them. We want to get to work on them. With that, Jim, I'll turn it back over to you.
Yeah. Thank you, Jason. And I hear you on all of that. And I'm at the Washington Post, and we're far from perfect too. So, fortunately, that's not the standard that any of us are held to.
Understood.
Katie Townsend, I'd like to turn to you and get your perspective on access to court proceedings and court records during the pandemic. History sort of shows that it's during times of crisis that often the public's access to information is curtailed. When an argument can be made, those are the times like war times and public crises. Those are the times when public access is actually more important than ever. Do you have a view from your national litigation perspective as to whether the public's access to court proceedings and court records has been damaged by the pandemic?
It's a great question, Jim. I think it depends a little bit on whether you're talking about what's happening at the federal level versus what is happening at the state level. One of the things that the Reporters Committee did as part of its sort of educational, the educational component of the work that it does, or informative component of the work it does in March, was it set about trying to get a sense of what was happening in individual courts, not just at the federal level, but at the state level as well. And it's a bit of a mixed bag. I think we've already highlighted some of the positives, and we've seen a number of those, and particularly at the federal level. So we've seen at this point now, as of late July, actually, every single federal court of appeals was live streaming its oral arguments, which was new. And that enabled people here in Washington, D.C. to listen to a court of appeals, a federal court of appeals argument taking place in the Fifth Circuit in Texas, something they could not have done before in real time. And I think what people are probably most familiar with is the ability to listen in real time to United States Supreme Court arguments, which was something that has never happened before and only happened because of changes that were made in response to the pandemic. So I think, are those steps positive? Those steps are absolutely positive. I think that's something that we hope at the Reporters Committee, but I think in general, we get many members of the public hope we see continue after the pandemic, sort of the precautions that folks are taking in response to the pandemic are no longer necessary. That said, I think it's a bit more of a mixed bag at the state level. Some of that has to do with resources. I don't think it's a lack of commitment to transparency per se, but I think some courts were just further ahead of the game. If you look at Federal Court of Appeals here in DC, for example, it was already live streaming oral arguments as standard practice. The Ninth Circuit has been live streaming video of its oral arguments for quite some time. They didn't really need to make many changes, and they had the technology already in place. But if you're going to a state court, maybe a state court in a jurisdiction that doesn't have those kind of resources, doesn't use that kind of technology, it can be much more challenging. The same is true of access to court records. Obviously, the federal system, you have PACER, so you can access things remotely. Certainly, there's a discussion to be had, I think, about whether charging people fees is appropriate during a pandemic when they can't go to the courthouse to obtain copies for free, but at least that access is there. And in some state courts, there wasn't any really formal mechanism or any mechanism to request electronic access of court records. And so particularly with respect to, I think, states, and this is not to say in all states or all sort of non-federal jurisdictions, but certainly in some states we did see it was far more challenging for reporters who were wanting to cover hearings or even to just get kind of information about what was going on. It was a lot more difficult. So there's really no kind of one size fits all answer, I would say. I think there's been some bright spots, and then there's been some places where it's been particularly challenging for the press and the public.
It's interesting, for years there was this debate, which you and I are well familiar with, about cameras in the courtroom, especially in federal courtrooms. And, the argument you would often hear is that trials will turn into like the O.J. Simpson trial. If you routinely have cameras in the courtroom, people will play to the cameras. It will diminish the public's confidence in government and so forth. In a sense, I mean, maybe this is an overstatement. You tell me, we sort of have gotten cameras in the courtroom through a side door, it sounds like, in the federal courts, for now, at least. Do you think that if in fact it doesn't turn out that everyone is playing to the cameras and there's, everything's becoming a circus, do you think that will give a foothold to arguments in the future that cameras should be allowed in federal courts just as a matter of policy?
I'd like to think so. I mean, I do think that the majority of courts have actually gone to audio first. So we're seeing more live streamed audio, which seemed a little bit more like a baby step, particularly since there were a lot of courts at least at the federal level, who were making same-day audio available, even if they weren't live streaming. So I think that seemed a little bit more like a half step. That said, there are courts like the Seventh Circuit, for example, who use their YouTube technology for their oral arguments before that court, and have indicated that they thought it worked well, and that the court is considering whether or not to continue that once in-person oral arguments resume. So I do think that, and you saw this with the pilot program that was in the Ninth Circuit that sort of preceded video live streaming of those arguments, that it doesn't really change the behavior of litigants or counsel. I think, you know, certainly attorneys who appear before courts, me, you, Jim, should know better than that to kind of play to the cameras. And I think most attorneys would know better than that to play to the cameras. And I think once people get used to it, it's one of those things. Once you get used to it, I think it becomes easy to sort of continue down that road. So I agree with you. We sort of got some of that remote access through the side door. Again, is it going to continue? I'm not so sure. I think I certainly hope so, and particularly at the federal level and at the Supreme Court level. I think there's a real value. You know, we've talked about the pandemic, but obviously there are a lot of other things going on in this country right now, and I think there's a lot of value for members of the public to see a branch of the government that is to watch it function. And that sounds very simplistic, but I think that there's some real, I think there's some truth to that. I think there's real value in people being able to see that work and how it works in real time. I think it builds confidence, frankly, in the system.
Jim, just to be clear, we're not seeing it though in federal trials. Of course, we're not having trials at all right now, but I think it would be a very different discussion if you're talking about victims and witnesses and defendants who are suddenly having their lives broadcast on TV.
Right. No, that's absolutely true. I had a Ninth Circuit argument recently, and so you don't get testimony from, you know, fact witnesses, and that doesn't raise those issues. But it was kind of surreal to see the judges in 3 different locations. You know, at one point a little kid ran back behind one of the judges in his house, and it's just a strange, you know, place we never thought we would be a year ago. I'd like to ask, oh, sorry, were you about to say
I was just going to say, embarrassing story. I had a hearing earlier in the spring when I was at my home, and my clerks told me later they could hear my 2-year-old daughter yelling outside my study. So, are you in your chambers now? At the I am, yes. I wish I could say this was my study, but.
Have you been, have the judges been going in, just out of curiosity more than anything?
I think among my colleagues, there are probably about 1/3 of us who are in on any given day. So I think a number of us are coming in periodically, obviously not having in-person hearings, but some of us, you know, need to get to the courthouse to interact with our colleagues and clerks. Other of us might be escaping interacting with little people back home, but either way.
I hear you there. I'd like to sort of pose a question to any of the panelists who want to address this. We've talked a little bit about what might be called the silver linings in play, the fact that people can watch court hearings much more easily in some cases than they used to be able to. The fact that there have been some improvements on public access, oddly enough, during the pandemic. This is just pure opinion, but I'd be interested in the panelists' opinions as to sort of how that balances against the damaging effects to public access that we've seen. And I guess I'll sort of call on Jason, because I suspect you would say that the damage has been greater than whatever has been gained in those little incremental victories, but I don't want to speak for you. I just would be curious to hear your perspective on that and that of others if they want to share their opinions on it.
I'm assuming not Jason Downs, me.
Correct, yes, I meant Jason Leopold. Although Jason
you know, I wish I could say that there was something that kind of balanced this out. And the reality is there isn't. You know, from where I sit, you know, as a representative of the media, it has always been a battle to obtain government records, from state, local, federal. I mean, the one great thing that took place during the past 6 months is there's been a case I've been following in New York, and I was able to watch it. I didn't have to go to court. I could watch that case, but it did not by any means outweigh, the aggressive work that I have been doing and continue to do, and my colleagues do, to try and obtain information. And if anything, it's just me on a soapbox for a moment. I mean, this is one of those moments where, you would hope that this would spur people into action, spur lawmakers into action to finally do something, perhaps make, funding available, so more people can be hired to, to process these requests. But, I don't know. It's no silver lining to be found from where I sit.
Yeah, I mean, from my perspective as a media lawyer who does a lot of FOIA advice to our newsroom, and supervises FOIA litigation occasionally, it's always been an odd statute in some ways because it's kind of an unfunded mandate. It creates all sorts of obligations that aren't really in many cases the resources and infrastructure aren't put in place to actually live up to the statute. The 20 days for responding being one of many examples.
Let me just note that, if I may, is that in one of the cases that that we have against the Justice Department, particularly for records related to the Mueller investigation, the records revolving around that 2-year investigation. The Justice Department said that there's a voluminous amount of records that obviously in one instance they said there could be 18 billion with a B pages of records, which I find hard to believe. However, they said they just don't have enough people to process this. But they do have money that they've spent on other things that just does not include FOIA. So what I was trying to say earlier, again, when we first started, which is FOIA is not seen as, it was not seen by these agencies as kind of a mission critical, if you will. And that's the case even outside of a pandemic, right? So you have, there is some funding there. It's just not being used in this way. So I'm sorry to interrupt you, what you were.
No, that's what I was interested in hearing from you. Have any of the panelists had any experience recently on, I mean, we all come to FOIA cases in different ways, and Judge McFadden, obviously we wouldn't ask you to talk about specific FOIA cases, but I'm interested in this idea that FOIA is not treated as mission critical, so to speak, by the government. Have any of the panelists had reason to believe that the government actually is treating FOIA as more of a priority? I'd just be curious to hear if this is the experience that all of us have had or not. Because I mean, I would say my personal experience has been that the FOIA officers that I deal with and the lawyers in the agencies are often quite good. And I've known many of them for years, dealing with them on various FOIA requests. And I feel for them because I get the impression, I don't know this for sure, but I get the impression that they have countless other FOIA matters that they're dealing with. And they still, for the most part, pick up the phone when I call and, respond to emails. So I guess when we say FOIA is not mission critical, to me at least, I would say that's more of an institutional priority criticism than a shot at the individuals working in these jobs. But I guess I'd be curious to hear if others have the same perspective on that.
Sure, I'm happy to take or at least start with that one. For us, mission critical is not only sort of being transparent, but also being proactive in putting out information. And so we don't always we're not only waiting for people to ask us for information, we proactively put out information. For example, between March and July, AG Racine led 7 OAG teletown halls with various segments of the district throughout the entire district, from local neighborhood commissioners to leaders within the labor field, to business leaders, to faith leaders, and to the Latinx community. We've also had 7 webinars addressing topics facing seniors, addressing topics related to children, mental health matters. We had 7 Twitter chats, mostly directed at young folks or young people. And we've also had an additional 15 or so video conferences that were organized by local groups that we've participated in, either AG Racine or I've participated in. And so we've also issued 8 consumer alerts and built a coronavirus resource page on our website. And we regularly update it with information all the time. So I say that to say, we try to educate consumers, seniors, tenants, workers, residents. We want to make sure that we're directing people to information so that it's not just that we're responding to information, we're proactively putting out information related to healthcare, related to housing discrimination, related to unemployment compensation, related to worker misclassification. So, and lastly, I'll say this, our Office of Consumer Protection has done a really good job. They issued a report in the middle of May detailing their efforts to address price gouging surrounding the COVID-19 crisis and other consumer-related issues. So I say that to say transparency is important to our agency. Again, we're an independent agency, so we're not subject to the control of the mayor or any other agency in the district, but transparency, but most importantly, proactively promoting information is a priority of AG Carl Racine.
Has your office, Jason, seen a spike in either consumer complaints or just complaints from DC citizens, members of the public, who feel like their legal rights have been violated during COVID in one way or another?
Unfortunately, yes. And specifically, we've seen an uptick related to the health facilities such as gyms, for example, charging people for memberships they can't use or failing to cancel memberships in a timely manner. So yes, we've seen an uptick in things like that. We've also seen an uptick, especially in March when the pandemic first hit. We saw an uptick in local convenience stores upcharging people for products such as Clorox or cleaning materials, PPE. That has slowed down a bit, but to directly answer your question, yes, we've seen an uptick in consumer complaints and we've gone out of our way to address them.
My next question is
Jim?
intended for Katie. Oh, sorry, go ahead, Judge.
Yeah, I was just going to say on the FOIA issue, I think I have noticed there was different agencies responded very differently. Some seem to shut down the FOIA offices altogether. Others, slightly to my surprise, I really couldn't tell any difference. It seemed they continued their monthly productions. Despite Mr. Leopold's experience, I think one potential silver lining for one of the major agencies that deals with a lot of FOIA requests, my understanding is in part because of the coronavirus, they've moved from a totally on-premises classified FOIA processing service to a non-classified virtual processing service where their FOIA officers can work remotely on non-classified matters, and that strikes me as a really smart development and probably one that would not have happened, at least now, but for coronavirus.
Jim, can I just also make a note? And by the way, Judge, is that the State Department that did that?
Yes.
Okay. I just also want to note that as far as my comments are concerned, is that the FOIA officers, the people who are actually processing this request, my criticisms are certainly not directed at them. And I've had so many conversations with these individuals during the past 6 months. Many of them are working at home, and they're simply just trying to get this done. So it's, as you noted, more of the kind of the larger issue, the policy, right? The policy makers that are that are involved in this. But as far as the officers are concerned, the analysts, that I'm so sympathetic to, to them, because they're just working their butts off trying to get this done and being inundated.
Yeah, great. I totally agree, and glad you're able to make that clarification. Katie, I wanted to sort of put you on the spot, if I could, for a second with a legal question, although I think it's one that I think I know how you're going to answer it. As you know, there's a First Amendment right of access to court records and court proceedings, not just trials, but pretrial proceedings and voir dire in criminal cases that's been recognized by the Supreme Court in several cases over the years. Do you think that and all of those cases, which were mostly decided in the 1980s, presuppose public access, being you can come to the courtroom and watch what happens. Do you think that it would be required by the First Amendment, therefore, to provide some sort of dial-in or listen-in option routinely for all criminal proceedings generally going forward, if you can't go in person?
Yes. Yes, I think that the First Amendment, to the extent the First Amendment it does provide a right of access to in-court proceedings, if there are in-court proceedings taking place, that right of access has to be honored. I think that there's also a common law, and in some jurisdictions, a First Amendment right of access that's been recognized to court records in both criminal and civil matters as well. And so that's true to the same extent. If there's an inability to physically get into the courthouse, then there has to be meaningful access provided in some other way. The First Amendment right of access is unique in the sense that it's we tend to think of the First Amendment as prohibiting the government from restricting things. But the First Amendment right of access to court proceedings is actually sort of an affirmative right, but it's one that's structurally required. It's required by the nature of our democratic government, requires oversight of what's happening in the judicial branch. So yes, that's a very long-winded way of answering a very, in my mind, easy question to answer, which is yes. The First Amendment does compel and require that the public be given access. And as I think Judge McFadden alluded earlier, in the criminal context, there's also a right to a public trial, and that's really intertwined with the public's right of access, First Amendment right of access to observe trials. So I think there's some, there's both the right of the public, but there's also the criminal defendant's right at play there. And I should have mentioned earlier, and I'm glad that Judge McFadden brought this up. I mentioned that there were differences that we were seeing between what was happening at the state level and what was happening at the federal level in terms of access to proceedings, particularly remote access to proceedings. There are also differences at the trial level and the appellate level. And I think it would probably not be surprising to anyone that the appellate level, it's sort of easier, frankly, for courts to provide access, because you're really, generally speaking, only talking about oral arguments. You're not talking about trials. You're not talking about status conferences and hearings and the same types of things that Judge McFadden is dealing with on a daily basis that are, I think everyone would acknowledge, are much more challenging to provide sort of remote access to. So, and that's true at the state level as well. Many state appellate courts have gone to remote, both live streaming and video streaming of appellate oral arguments in a way that's in a more seamless way, I would say.
Right. I would suggest it's probably just easier at the appellate level in general.
No argument here. Yeah, no doubt. And they're not dealing with juvenile witnesses and crime victims, and it's just they don't have to get their hands dirty as much as the rest of us. We have about 10 minutes before audience questions, so I wanted to just go back to each panelist and give each of you an opportunity to, if you want, to prognosticate a little bit. And the question I'll ask each of you to think about and address is, do you think there will be any lasting impact to public access to the government and court proceedings as a result of the pandemic? Or is this a blip on the radar, and once we get back to normal, things will just be as they were before? do you think there will be any lasting impact, for better or for worse, on public access once we get to the other side of COVID-19, whenever that may be? And God help us. I hope it's somewhat soon, but who knows when it'll be. So anyone who wants to tackle that one first, feel free to weigh in.
I'm happy to start us off. This has been said before, but I've got to reiterate it. I would like to see that court proceedings be available by phone, by streaming, by video chat. I mean, these measures have really opened the court doors to observers and for people who want to participate. Anecdotally, we've heard from, for example, our Child Support Services Division that participants and litigants feel as if they have more access to the court. And so I say that to say we're hoping that these changes last. We've seen them be helpful not only to promoting transparency, but also helping litigants that otherwise have a difficult time making it to court. On a very real level, our office has now realized that we have the capacity to telework, that we've got the capacity to do our jobs from home. Prior to the COVID crisis, we've got, I guess, 650 or so employees or FTEs, and the overwhelming majority of our employees worked on site. We had a fairly narrow work from home exception. And now, at the drop of a dime, we had to pivot, and over the course of 5 days, we transitioned to over 90% of our employees working from home, and we see that we can do it. So now that we know that we can do it at a high level, I think that these are changes that we've got to look at and see, where's the right balance? I don't know that 100% telework or 100% in the office is the right balance. I've seen some reports that, a 60-40 split or so is a good balance to strike. But I think that agencies should look sort of what their unique needs are and whether or not teleworking can continue and whether or not we should continue to have access to the courts via web conferences and telephone.
Thank you, Jason. Anyone else care to put your prognostication hat on? And will this be a blip on the radar, or will there be some sort of permanent impact? And we won't hold you to these answers. We're all guessing here.
I'll weigh in as well, Jim.
Sure.
And I feel like it's, I've only spoke about doom and gloom in a climate of doom and gloom. Yeah, I think there is going to be long lasting impact, as it relates to the Freedom of Information Act. And I've touched on that already. And that is, what these agencies now have to deal with, which is a massive backlog. And an obligation in some instances to reduce that backlog. And so how will they do that? Well, they'll be sending out letters to requesters saying, are you still interested in these records, when they should not be sending out letters like that. Records will not be processed in a timely fashion. There will likely be more of an effort, and I've seen it, to, have political appointees weigh in on what should and should not be released. And I have seen that over the past 6 months. So, it will eventually, as you move forward, you still have to deal with what we have here. And so what will that result in? Well, that may result in more of an uptick in litigation. Right? I mean, I can tell you right now that that's certainly what my plan is, right? I need records, I need to inform the public, and I need to get this out there. So what's the quickest way to be able to do that? And it's to litigate. So, that is sort of what the impact is. And until that is kind of dealt with, I think the agencies are going to constantly be playing catch up here, trying to catch up to what they've had without any sort of meaningful policies in place to kind of fix what's been broken, but what's now even kind of really broken.
Yeah, that wasn't too doom and gloom, I didn't think. Realist. Katie, do you have any thoughts on what what lasting impact we're likely to have?
I'll add maybe I'll be a little bit doom and gloom and a little bit optimistic. I think on the doom and gloom side, I think Jason's right that the backlog that's probably being created, at least within some agencies, is going to be very difficult for agencies to overcome. We saw that from the shutdowns. I know it feels like a lifetime ago, but when there were federal government shutdowns, which stopped FOIA processing, some agencies are still recovering, or not even recovering, but they added so significantly to their backlog just during that time period that it's going to be difficult, I think. So that's sort of the negative prediction that I feel unfortunately very confident in. On the positive side, I would love it if agencies at both the federal and state level would take advantage of this opportunity in some ways to do a couple of things. One that Judge McFadden's already alluded to, which is think about technological solutions that may make things a bit easier for them to process and process things more easily and more quickly. I think that's sort of an important component or piece of the puzzle when it comes to sort of solving the FOIA problem. I also think something that Jason Downs has talked about a couple of times, which is proactive, what we would call affirmative disclosures, but proactive disclosures of government records and information that people want, that people are going to ask for, and particularly in the midst of a public health crisis where data on infection rates and things like that that's information that journalists want, that's information the public wants. But there are scores of sort of sets of data and information like that agencies would be better off if they made proactively available so that they didn't have to wait for Jason Leopold to come and ask for them and then sue them when they didn't give them data.
Right, and the suing actually is, it seems like it should be the fastest way to get the records, and sometimes it is, but sometimes it also just ends up taking even longer. Judge McFadden, do you want to weigh in on this question? Any thoughts about whether there are any lasting changes that are likely to result from the pandemic to your corner of the world?
Yeah, a couple of things. First, I'd echo what Mr. Downs said about the teleworking. I think a lot of us in the government have figured out ways to be even more efficient than we were before by doing more work from home, and I think that could redound to everyone's benefit in the long term. I'll tell you, I've found that particularly for some of those short status conferences that I've typically been pulling attorneys in for, say on a FOIA case, it strikes me that, going forward, I'd be a lot more inclined to try to do them just via teleconference. And I think that's probably going to save everyone time and effort. I was just looking in terms of what would need to happen from a policy standpoint. Currently, you've got a federal rule of criminal procedure that bars any broadcasting of criminal trial proceedings, or actually any criminal proceedings, period. You also have a judicial conference policy that typically bars the broadcasting of trial court proceedings whatsoever in the federal level. As I said, the CARES Act has preempted those while we have the national emergency. But I think long term, for you to see some of these trends to continue, there would need to be, at the very least, a change in judicial conference policy, and quite possibly also a rules change if there was going to be a change on the criminal side.
Okay, thank you. We have a little bit of time for audience questions, and it looks like we do have a number of them. So let me see if I can do this correctly.
Yeah. And Jim, you can just skim through and pick them, and we'll clear them for you if you want to go in whatever order.
Okay, I'll just go in the order that they're open on my screen. This question is from Lynn. In regard to the judge's remarks, what was the backlog before the COVID-19 changes, and what is the backlog now? Have there been considerations of changes to any procedures or processes to address the backlogs? Judge, did you get that?
Yeah, I think so. I'd say on the civil side, I think I'm probably doing better than I would have done otherwise, in part because we don't have the criminal cases taking up the time they typically would, and in part because a lot of the other things that we would typically be doing aren't happening right now. I think I'm probably, and a lot of my colleagues are probably making really good progress on the civil side. On the criminal side, the DC District Court is a little unusual in we have a relatively small federal docket, or criminal docket, certainly compared to Superior Court or most other federal districts. I don't know that I would have said there was really a backlog of trials in the past. I think now the latest stats I heard there were probably somewhere between 20 and 30 criminal trials, jury trials that are waiting to be scheduled. That fluctuates, as you can imagine, as people accept pleas and new cases come in. But I think there is going to be a backlog there, and especially the pinch point, as I said, will be picking the jury, where you have to have 50 people probably in the ceremonial courtroom. We can probably only get one trial started at a time. After that, they can probably go to the individual judges' courtrooms, and I'd like to think we can make pretty good progress on moving through that backlog.
Thank you. That's very helpful. A question from Richard Hoffman. Has the Superior Court, for example, changed the restriction on public access to computerized case files that required everyone except the attorneys in a case from accessing the file online except from courthouse kiosks? I think Jason Downs, who would have been in a good position to address that, since it's a question about the DC Superior Court, I think he had to leave a little bit early, but do any of our other panelists know the answer to that?
Still got Jason.
Oh, we do? Okay, I'm sorry, Jason. I thought I saw you.
No problem. Happy to skip it if you like, Jim. But no, I'm
No, please.
So, in terms of computerized access, there is a website that was up before the COVID crisis hit, where there was limited access to case-related information. The case docket, for example, was available online before the pandemic hit. Since the pandemic hit, I am unaware of any changes to the availability, whether it's the current online system or those kiosks that were on the 4th or the 5th floor. I am unaware of any changes. As of this moment, I don't believe there have been changes, but in my communications with the Superior Court, I candidly have not asked the question. And so while I've spoken with the Superior Court a few times about the pandemic, I've never asked that question. As of now, I haven't gotten any information that has changed.
Okay, great, thank you. And I'm glad you are still here. I saw a note saying that the Office of Attorney General has left, but it might have been a colleague of yours or something. Yeah. Here's a question for Katie from Patrice McDermott. I think Jason Leopold also could probably address this if he wants to take a crack at it, but I'll sort of throw it open to both of you. What kind of technological fixes would aid agencies in FOIA? FOIA online does not seem to have helped enormously, and some agencies have misused it to create hoops. So I'm curious. I'm curious whether you would agree that FOIA online does not seem to have helped enormously, and with the other part of the question, of course.
Yeah, and I would start with the other part of the question first, because I was thinking of technological fixes more, less on the public-facing sort of request or submission side and more on the internal agency side. I think one of the things that has, or maybe that might be surprising to folks, particularly people on this call who may be attorneys who are in private practice, who are used to, for example, kind of document review platforms that they might use in private practice. If they knew kind of what was used by the government, they might be kind of shocked. The types of document review platforms that are used just don't have the same kinds of capabilities of, deduping and searching and doing things that would quite frankly, make the job of a FOIA officer responding to requests probably 1,000 times easier and more efficient. And so I think, you know, and this was sort of a pre-pandemic thought process, and I can't say it's mine because a lot of people in the FOIA and open government community have been talking about this for quite some time, but improving the ability, basically making FOIA officers' lives easier could also speed things up and reduce backlog and end up being better for requesters as well. And Jason, do you have thoughts on FOIA Online? He's itching to talk about FOIA Online.
You know, I feel like I've been such a negative person the whole time, and I do have thoughts on FOIA Online, and I think it's horrible. It's just, it's terrible. It's, you know, it's inefficient in my experience. Maybe other people have better experience with it. But no, I think you captured everything perfectly, Katie. I mean, that's certainly, when you said deduping, by the way, that's like my ears perked up, because it's something that we constantly have to, you know, to address with, you know, with the agencies when it comes to processing some of these requests. And, but yeah, so good job.
You know, you're a FOIA. Yeah, you know you're a FOIA nerd when deduping gets your ears perked up, or legal nerd.
Jim,
got to include myself.
Jim, could I chime in with a question along those lines, if I may?
Absolutely. Yes.
So I wonder whether Jason or Katie or anyone else has any suggestions as to sort of storing files better to make them more accessible to FOIA officers. So instead of, you know, technology is one piece of the puzzle, but I wonder whether you've seen different government agencies store documents differently on the front end to make them more accessible, or to make the FOIA process easier on the back end.
I'd have to give that some thought. I mean, nothing immediately comes to mind, to be honest with you.
Okay. If there's any, I say that to say, look, when I say we're looking to constantly improve, we really are. And so to the extent that there are, you know, technology may not be what we're going to be doing over the next couple of months in the middle of a budget crisis, but to the extent that we can store documents differently, or if you have ideas of how to sort of intake documents, that may really be helpful. So we'd love your thoughts in the coming days or coming weeks.
I would say one that we've seen, one that I would say if the agency isn't already doing this, and I sort of recognize that at the federal level, there may be different requirements for compartmentalization for certain agencies for security reasons, but sort of setting that aside, I think one of the things that we've seen as useful is when, or at least speeds things up in terms of identifying responsive records, is a centralized sort of email system that can be searched and cover basically everyone's governmental email account. Not all agencies have that, and it's really different at the state level across the country, but that's one thing that can really make everyone's lives easier when you have to go when you have to go ask individual email records custodians to search their email. Can be really complicated. So that's an easy one that comes to mind, but I would have to give some thought, I guess, as to other suggestions.
Thanks, Katie. That's helpful. Thank you so much.
Thank you all. Here are two questions. I'll sort of put these together because they're both related to court proceedings, and so I'll direct these to Judge McFadden, although any of you who have thoughts on them, feel free to address them. Two questions relating to the courts. One from Dana, who says, should all courts be considered essential and be open during this and perhaps future influenza-like pandemics? And if only certain courts are essential, should that include family courts? So that's the first question. Should courts be considered essential and remain open? And then a question from anonymous attendee. There are many hearings that are done by Zoom, et cetera. What about a client's right to counsel if counsel is not seated with the client? Judge, do you want to address either or both of those?
Sure. Well, I think we all like to believe that we're essential. So I will say, yes, I'm certainly essential, and I'm sure all judges are essential. I think obviously the devil is in the details. The idea of courts just throwing up their hands and shutting down is not acceptable, but how we continue to soldier forward in a way that is ensuring the safety of the public, the staff, and attorneys is a much trickier question. And so I think, you know, we've all been trying to respond to that. And frankly, whenever I think things are rough over here, I think of my colleagues across the street at the Superior Court who have a much higher criminal caseload and much smaller courtrooms. And so, you know, whatever social distancing and backlog issues we're facing, they are facing them to exponentially higher. The council issue is a really tricky one, and one that I'll tell you how we're trying to deal with that. On criminal cases, we, when at all possible, we do a video conference, much like Zoom, just not as easy. But you also will, now we're trying to ensure that there's a telephone line or some sort of connectivity directly between the jail or wherever the defendant is and his attorney, so that if needs be, they can mute their Zoom conversation and just speak back and forth with one another. I just had a situation, I think, a day or two ago where you know, the defendant wanted to speak with her attorney, and unfortunately the telephones weren't working, and so the rest of us just signed off the video conference technology so they could speak, and then we got back on together. So we do try to allow for that, but it, you know, candidly, it is harder, and it takes a defendant or a lawyer being willing to kind of interrupt proceedings and say, hey, I really need to talk with this person, rather than slipping a note or whispering in the ear. So there's no doubt that it is, you know, it's not as seamless as it would be in person.
Thank you, Judge. I think we have time for one or two more. Emily Tatro asks, what legislative changes in FOIA may be in order as a result of particular problems COVID has highlighted? Anyone who wants to address that one? I guess I would actually like to say something about that. I think, to me, it's not really a legislative change. It's a FOIA. In fact, it's not at all. But I think allocating more resources to FOIA generally at the federal level would be high on our wish list as media organizations, just because I would say that the COVID crisis has heightened something that was already apparent, which is that FOIA is, you know, understaffed. FOIA officers are overworked, overburdened, et cetera. But Jason, Leopold, or Katie, or any of the panelists, if you want to address that, do you think there are legislative changes to FOIA that should be considered as a result of the pandemic?
I don't necessarily think as a result of the pandemic, as you noted, Jim. I mean, you know, more resources. I think the pandemic just certainly sort of has exacerbated this problem that has existed. And look, you know, in 2016, there were FOIA amendments passed that President Obama had signed into law. We waited a very long time for those amendments. You know, it codified the Holder memo. The one thing it did not do is that it did not, you know, when Congress, you know, passed these amendments, they did not make any additional funding available, you know, to agencies so they could hire more people. So, you know, and we've seen, I think we've even seen, maybe I could be mistaken, but during the pandemic where, you know, the usual champions of transparency have stepped forward to say that, you know, they did not appreciate what was happening in terms of the, you know, shutting down the FOIA operations. But that's pretty much it. You know, letters have been written, and you know, I think it really does come down to perhaps money. I always advocate, you know, by the way, I feel like I need to throw it in for, you know, criminal penalties for not giving records and when you should be giving us records. And, telling us, for essentially for routinely violating the law. But that's another panel, perhaps. But I think that, yeah, I really do think it comes down to funding. It is certainly what I have heard quite a bit from, from the FOIA officers, from the analysts that are processing the requests. They need help. They're burdened, so.
Okay, thank you. It's 6:27, there's only one more, so why don't we get to it quickly. Lynn asks, has there been more progress in the development of computer applications to support legal procedures, files, cameras, etc.? And are there requests for more funding to allow the implementation of these applications? Anyone want to take a crack at that? Has there been any more progress in the development of computer applications to support legal procedures? To file, cameras, etc. Yeah.
This may not be directly responsive because it's not related to FOIA, but I will say that yes, we are in the process of modernizing our technological capabilities as it relates to processing child support payments and handling child support cases. We have a system here in the district that is antiquated is an understatement, and so we're very fortunate to be in the process of modernizing our child support system. And so that is in the middle of a pandemic, and the COVID has not slowed it down. We are very far along in the process. So in our office, yes, that we are, we're still technologically moving forward.
Great. I think we need to wrap it up there. I promised everyone we'd be done by 6:30. I want to thank CCE again, and also thank all of our event sponsors, Aiken Gump, Errant Fox, Arnold and Porter, Boyce Schiller, Davis Wright Tremaine, Lockheed Martin, and Zuckerman Spader. Again, if you want to consider making a contribution to the Council for Court Excellence, it's www.courtexcellence.org. And please join me in thanking our panelists for this excellent discussion. Virtual round of applause for our 4 panelists tonight. And thank you so much for being with us, all of you. Good night.